Namaskar dosto, I am absolutely thrilled to have you here for this explainer. Today, we're going to do something really special. We are building a definitive guide that bridges those theoretical law school principles you read about in textbooks right over to the practical, sometimes gritty reality of the Indian courts. So whether you're a law student meticulously taking notes or a seasoned practitioner just looking to refresh your perspective, we're going to examine these concepts from both the student guide and the court perspective. All right, let's dive right in.
Think of this as our study syllabus for today. First, evaluating medical evidence. Second, police recovery and witnesses. Third, the right to be heard. And finally, evolving laws, the BNSS.
Starting with Section 1, Evaluating Medical Evidence. Looking at this completely through Qanun ki chashme se, the lens of the law, we straightaway see a pretty stark contrast. Take this landmark 2001 Supreme Court judgment, for example. Initially, the examining doctor hastily scribbled multiple bruises all over the body on the medical legal certificate, or the MLC. But a bit later, a detailed post-mortem autopsy report showed meticulous precision, detailing exactly 25 specific injuries, along with their exact dimensions and locations. So the really crucial question here is, when a trial court faces these two conflicting records, which one actually holds the legal weight?
Well, the Supreme Court explicitly ruled that no court can afford to ignore a meticulously precise autopsy report merely on the strength of what another doctor hastily scribbled at the initial stage. The court rightly observed that, the first doctor might have just been in a massive hurry or simply knew a detailed autopsy would follow anyway. What you should really take away from this is that in the courtroom, thoroughness and precision will always trump a hurried initial assessment. You simply cannot use minor discrepancies in an early MLC to throw out a comprehensive autopsy. It just doesn't work that way.
Moving right along to Section 2, Police Recovery and Witnesses.
Let's break down these legal tests. Under Section 27 of the Evidence Act, when the police recover a piece of evidence based on a statement made by the accused, it is considered absolutely formidable evidence. But what if there are no independent witnesses, like no outside gawah present during this recovery? Well, the Supreme Court is crystal clear on this. The mere absence of an independent witness does not automatically taint the police evidence. It's actually up to the accused, during cross-examination, to prove that the police officer's evidence is unreliable. The court also clarified a major point of confusion here. General searches under Chapter 7 of the CrPC, where officers are essentially prowling or guessing where items might be, absolutely do require independent locality witnesses. But a specific recovery based on the accused's exact information under Section 27, that is a completely different statutory beast.
I absolutely love this quote from the judgment. The court literally stated it's an archaic notion to approach the actions of a police officer with initial distrust. Applying Section 114, Illustration E of the Evidence Act, the court noted that we must presume official acts of the police have been regularly performed. Basically, the courts have to presume police records are trustworthy right out of the gate, unless the defense steps up and proves otherwise. It completely shifts the entire burden of skepticism.
All right, let's pivot to Section 3, the right to be heard. Now we shift our focus over to the abiyukt, the accused. You're going to hear this Latin maxim in your very first year of law school, audi alterum partem. But let's anchor it immediately with the Hindi equivalent, dono pakshon ko suno. Hear both sides. It is a cardinal principle mandating that no person should ever be condemned without a genuine opportunity to present their case in a fair trial. Looking at this through the perspective of the State Judicial Academy, this right, specifically under the old Section 313 of the CrPC, is not just some procedural box you check off. It is a fundamental constitutional right flowing directly from Article 21, the right to life and personal liberty. Questioning the accused, presenting the incriminating evidence against them, and genuinely asking for their explanation is the absolute backbone of a fair trial. It cannot just be an empty ritual.
But here is where theoretical law meets real-world friction. The Supreme Court, in cases like Sajan Sharma v. State of Bihar, has actually had to issue strong warnings. They have openly deplored trial courts for the mechanical recording of these statements. If a judge just mechanically reads out a massive, confusing list of evidence and demands a simple yes or no, it completely defeats the constitutional purpose of that dialogue. The questions have to be specific, and they have to be intelligible to the accused.
Which brings us to Section 4, Evolving Laws, the BNSS.
For generations, lawyers have just instinctively memorized Section 313 for the accused's statement, while under the new BNSS, this becomes Section 351. But the truly profound shift here is regarding trial presence. Traditionally, physical attendance of the accused was the strict, unquestionable general rule. Now, participation, and that includes the reading of evidence and questioning, can actually be done through audio, video, electronic means. That is a massive technological leap for Indian courts.
Of course, systemic shifts like this don't just happen without some rigorous debate. Looking at the Parliamentary Standing Committee reports, we see a fascinating multi-sided discussion. For instance, there were debates about new provisions allowing up to 90-day police custody in certain specific circumstances. There were also strong arguments that while audio-video trials definitely improve efficiency, they might inadvertently limit the principle of open court, public access, which is so crucial for the integrity of the proceedings. We even saw extensive debates over the naming conventions themselves. Some lawmakers voiced concerns over Hindi imposition, noting that BNSS translates to the Indian Citizens Protection Code, 2023, and they argued for dual-language titles. Ultimately, the committee's real focus was on finding that delicate balance between leveraging modern technology and maintaining deep foundational public trust in the justice system.
And that brings us to our final thought for today. The overarching vision behind all of these reforms is a stated shift from a purely punitive framework to a more rehabilitative and reintegrative one, essentially creating a procedural shield for citizens. So the question I want to leave you pondering today, whether you're a first-year student or a veteran practitioner, is this. As we integrate technology like audio-video trials and completely reshape the fundamental procedures of evidence and rights, how will this redefine the future of Indian courts for generations to come? It's a truly fascinating systemic shift. Thank you so much for joining me on this explainer, and keep learning.